Hi, tax attorney John Hyre here, and going through a few more questions just for frame of reference. I used to have something called the inner circle. We used to take questions and do a good deal more besides. So I thought I'd give you a sample. We're restarting it, and so we're taking a bunch of questions and posting them. So we'll get started. This is a complicated foreign asset protection structure. I don't have to go through it. I mean, I looked at it. I have a trust or an LLC overseas. The first thing that the author concedes is we are not using this to change our taxes, right? If you have a trust or an LLC or whatever overseas, and you're a U.S. citizen or a U.S. permanent resident, or you reside in the U.S. and you're treated as a permanent resident under the code, even if you don't have a green card, and you try and reduce taxes with overseas entities, that can get you put in prison. There are a few cases, they're pretty rare, when that will work. Everything I've seen promoted as an advertisement on, say, Facebook or that similar sort of feed has been absolute criminal garbage when they say, we're going to set up a foreign trust and you're going to reduce your taxes. We're going to set up a foreign entity, you're going to reduce your taxes. And the author says here, I'm not looking to do that. I'm just looking for asset protection. So how does that work with foreign entities? You have to have liquid assets. I've seen people advertise, I have a foreign trust and it has a lien on my United States real estate rental, and therefore the foreign law applies to protect me. No, happens all the time. A U.S. judge says, oh, you have a lien in the U.S. on a U.S. property. Oh, but the lien is from a foreign entity. We better follow foreign law, said no judge ever. The judges consistently will say it's a U.S. property, the U.S. lien, we are going to follow U.S. law in terms of asset protection. In other words, can creditors get at the property? Is the property available to be taken by creditors? They don't care that the property is owned or the lien is owned by some foreign entity. That doesn't work. You need to have an entity that's actually overseas. And that's, again, the author here thought it through and is like, okay, we've got liquid assets that are actually located to a trust, and he gets into a structure that's irrelevant to me. It has to do with the Cook Islands and Liechtenstein, and this one has the trust, and this has the LLC, and we have this just bitchin' arrangement between the two that's proprietary and special. Nobody cares. Here's what a U.S. court cares about. Here's what matters. There are two big considerations, one for you, one for the court. Here's what the court cares about. Is the trust overseas? Is the asset, the liquid asset, overseas, whether it's in a trust or an entity. And by the way, there are reporting requirements. When you put assets overseas, there are reporting requirements, and there are massive penalties, sometimes criminal penalties, for failing to meet the reporting requirements. So again, this is tax neutral, and you have to report it. The IRS wants to know, what do you have overseas? This does not exempt you from that. This is purely an asset protection move. Here's the theory. There's a creditor, and I disclose my assets to him. There's a judgment against me, and we're in court, and under penalties of perjury, I disclose my assets, because if I don't and they catch me, I have committed perjury, and now I have committed a felony. I may go to jail. That is a problem. It's a classic cover-up is worse than the crime situation. So I've got assets overseas. They're actually overseas, not in the U.S. I'm questioned by a creditor, and they ask, give us a list of everything you got. Is usually a very broad question. You have to include this. And if not, and they track you down, you have a perjury problem, which is much bigger than a money problem. So you tell them, I have this overseas trust, and good luck getting at it. They're not giving you squat. Good luck. How does that usually go? Usually you have a lot of leverage. Usually creditors don't want to play that game. Usually they're willing to settle 10, 20 cents on the dollar is what I've heard thrown around out there, 10 to 20 cents on the dollar. So if you have a creditor that doesn't want to do a lot of work, and they would have to, going after assets in an offshore trust, offshore entity is difficult. It takes a lot of work and effort, and a lot of creditors don't want to do that, and so they'll settle. Now, if you get a wealthy creditor or a highly pissed off creditor, or worst of all, a highly pissed off wealthy creditor, they do have an angle, and it does work. The court, they will submit an order to the court that you must be forced by court order to repatriate the foreign assets. Now, your argument will be That's impossible. It's the impossibility defense. The way the trust is set up is when I tell the trustee, send the assets back to the US, the trustee says, no. What's the problem in that scenario? The judge then puts you in prison for contempt of court. And you go, but that's not fair. I can't bring the assets back if I wanted to. And the judge says, well, we're going to test that out. We're going to put you in prison for a while and see if the assets appear. And by the way, in every one of these cases, almost every one of them, there was no prison time. The assets appeared, showing that the impossibility defense was fake. It was possible to repatriate assets. There have been a few cases I've heard about where somebody actually spent a little bit of time in the slammer and decided it was not to their liking, and the assets were repatriated. So it's a powerful asset protection device if what? You have liquid assets overseas, and you are in court, and the creditor doesn't want to go through the expense and hassle of getting the judge to order you to repatriate the assets and then the contempt proceedings that follow if you don't. But that does happen. So nothing's bulletproof. This is Kevlar. It works a lot of the time, but Kevlar covers your chest and your arms, maybe your legs. It doesn't cover your face. You get shot in the face, you die. There are vulnerabilities to every sort of armor, including this one. The other person you want to be concerned about is the overseas entity that now has control over your liquid asset. You want to be in a reputable jurisdiction. Now, I don't really care. Some jurisdictions claim to be better than others. None of that matters. Think about it. The Cook Islands has this super special mega deal with Liechtenstein, and between the two of them, the assets move back and forth, and you can never catch the assets, and these people are clever, and their laws are better. The U.S. judge doesn't care. If push comes to shove and they say, bring back the assets or we put you in prison, that's the discussion. They don't care if you're in Liechtenstein or Honduras, not recommended, or the Cook Islands, or they don't care about the jurisdiction. The contempt order telling you to repatriate is a contempt order telling you to repatriate. Why do you care about the jurisdiction? You want the cheapest credible structure. You want the cheapest credible structure. Credible is important. It's the most important word in the sentence. It's a jurisdiction where if the lawyer or the trustee rips you off, because that has happened, Americans put assets overseas to protect the asset, and the person who's supposed to protect the asset takes the asset. Bit of a problem. That's why I would say Honduras, maybe, sort of suboptimal. Belize doesn't make me real happy. Kind of a corrupt jurisdiction. I'm not really convinced that they're going to take good care of my assets. Now, the Cook Islands and Liechtenstein, lawyers there have a lot to lose. The trustees there have a lot to lose. There are laws, because those jurisdictions make money on this, and they don't want bad actors, a bad trustee or a bad lawyer, undermining their reputation. And so you generally don't see misbehavior by lawyers and trustees in those jurisdictions. That's what you want. That's what I mean by a credible, trustworthy jurisdiction. And then you want the cheapest one. All these bells and whistles and moving parts, unless you're an expat, I'm assuming you are a resident in the US, they can physically reach your body and put you in a cage. Now, if you're an expat, things change. That's a whole different ball of wax. Frankly, what I'm not qualified to discuss, because what are two of the taxes that I don't address? I don't do much with foreign taxation. I don't do a lot with nonprofits in terms of structuring. So, man's got to know his limits. Those are mine. So if you're a true US expat, or you were never a US citizen and you're not a US permanent resident, not subject to the jurisdiction of the US, it's a different ball of wax in terms of what these structures do. But if you're a US resident, US citizen, and the courts here can reach you and stick you in a cage if you don't obey a judgment, you're more concerned about the assets are offshore. That's all you care about. They're offshore. All the bells and whistles don't matter. You want a trustworthy jurisdiction. And then all things being equal, all right, we got 10 trustworthy jurisdictions. Which one doesn't charge me an arm and a leg for all the bells and whistles that I don't care about? So that's the answer to this question. And really the answer to any question that has to do with using foreign trusts for asset protection. Again, not for tax avoidance, because really it would end up being tax evasion.